Welcome to the Evalesco Healthy, Wealthy and Happy podcast. The information provided on and made available through this video and podcast does not constitute as financial product advice. The information is of general nature only and does not take into account your individual objectives, financial situation or needs. It should not be used, relied upon or treated as a substitute for specific professional advice. We recommend that you obtain your own independent professional advice before making any decisions in relation to your particular requirements or circumstances.
Welcome to the Evalesco Healthy, Wealthy and Happy podcast. My name's Jeff and I'm pleased to be your host today. And I'm very pleased to be joined once again by Senior Financial Advisor Melody. Welcome back, Mel.
Thanks, Jeff.
Today we're going to be talking about a very important topic of estate planning. I'm going to dive deeply into what's involved in estate planning and some case studies around some issues that we've seen clients experience. But before we do that, as we always start with, Mel, tell us what you've been doing to be healthy and happy lately.
So I've recently gotten back into reformer Pilates, which I really enjoy.
Yeah.
So that's been a regular scheduled event on my calendar now, which is good to get back into it.
Excellent. Good to have that routine and lock it in.
Mm-hmm.
Very good. So onto the topic of the day, estate planning. I guess start off with, what is estate planning?
So essentially it is having the relevant documents and discussions around what you'd like to do with your assets once you pass away, primarily, but also if you're not able to make instructions or act on your own behalf due to mental incapacity or being in a coma, something like that, around financial assets, your financial affairs, but also your lifestyle and medical choices as well.
Okay, so you mentioned it's about documents to start with. So what are some of the common or important documents that need to be part of an estate plan?
The most common one that people are familiar with is a will, which essentially lays out who you'd like to receive your assets and how when you pass away. There's also a power of attorney and enduring guardianship as well, which essentially the power of attorney deals with your financial affairs and your enduring guardian deals with medical and lifestyle choices. To supplement that, there's an advanced healthcare directive, which details what kind of care you want to receive in certain situations or not receive, as the case may be. And then also, which people don't often think about, is superannuation beneficiary nomination. So super typically doesn't form part of your estate automatically, but it is an asset that needs to be directed when you pass away, and so having that beneficiary nomination in place will fulfill that.
Okay, so what's the difference between a power of attorney and an enduring guardian and an advanced care directive, those sorts of things?
Yep. So a power of attorney can act on your behalf to make decisions around your financial assets or any of your financial affairs. So that would have to do with bank accounts, investments, property. They can't make decisions on your medical or lifestyle choices. That's where the enduring guardianship will come into play. They can be the same person or they can be different people depending on obviously who is better to serve you in that role.
Mm-hmm. And is an advanced care plan or directive, is that normally part of the enduring guardian or is it a separate?
It's separate, but it kind of comes hand in hand because it's good to sort of spell out how you would like your treatment to go if you can't voice that at the time. Having a conversation with your appointed guardian as well would help them flesh out those details as well to understand what your priorities and what you want to happen would be. Not always is it completed, and sometimes it will depend on how strongly you feel about your particular care needs. If you have a lot of experience or chronic illness, that can be something more top of mind, but for others they may not, they just want whatever treatment is sort of standard in their medical style.
And when and how do these things kind of get enacted? So you can draw it up, but how do you choose when a power of attorney becomes in effect? Or
Yep.
what's-
That's a good question. It can be tailored to your circumstances as you'd like. Some common ones we see is upon signing the power of attorney, which means as soon as you've got it drawn up and everyone's signed and witnessed it, that person can then act on your behalf. Where you want to limit your power of attorney to only act in certain situations, like when you can't manage your affairs anymore, you can stipulate that inside and have more limited conditions around when that comes into play. So it's really key to discuss with your estate planning specialist, lawyer, who will go through the options and what that will entail for the attorney and for you, especially if you have people who you might want to appoint them in certain situations, but not sort of a general, all-encompassing type of power.
Mm-hmm.
Yeah.
Okay. That's right. What are the roles, or who are the people that might be important when considering an estate plan?
Yeah. So for power of attorneys, you will need someone to nominate as your power of attorney or enduring guardian, and usually someone that you trust to follow through with your wishes. Essentially, they are bound by law to act as if they are acting as you, so everything has to be on behalf of for your benefit only, unless it's stipulated inside. There are certain provisions can be made for gifting and providing for living expenses for someone. But yeah, it is a very trusted role, so they have a lot of power once they do have the authority to act as if they were you.
Yeah.
So it's very important to think about who would be fitting for you in those roles. For a will, you also need to nominate an executor, which is someone who will essentially administer your estate in line with your wishes. So it is a very administrative heavy role usually, locating all your assets and liabilities, trying to find out, they make sure they've covered everything, that they've paid who requires paying in terms of debts and liabilities, before distributing it out in accordance to your wishes. So sometimes they're one and the same as the beneficiary, who is the recipient of your estate, but sometimes you might want to nominate someone who's a bit more, minded around the admin and life admin and financial aspects of that. You can also enlist help in terms of professionals to help you with in that executive position as well. Yeah. If you do have kids, you'll have to think about who nominates as a guardian, which is different to the enduring guardian that you nominate for yourself.
Yeah.
So inside in your will, you will stipulate who you would want to look after your kids from a sort of lifestyle perspective, but also financially, if you're leaving them assets, who's going to manage that? And it could be the same person, or it could be someone different as well. So definitely, depending on the structures you use, will have different roles to fill.
Yeah. My experience is that guardian piece for the kids is often a sticking point and a hard conversation.
Yeah, definitely. So sometimes it's, people think of next of kin, which makes sense, but you also have to think about who is potentially going to be around if something happens to you, and also from a logistics perspective, if you want to keep them close, then perhaps using someone who lives close to you rather than overseas or in a different state. Again, all these considerations around could be factored in when you're putting these together.
Yep, excellent. What other information goes into or should be included in putting together your estate plan?
So you should really have an idea of, firstly, what you have and what you have to, how it's structured to actually transfer that of assets. So sometimes if other entities involved, that doesn't necessarily mean it's your asset to pass on. So it's really key to understanding your position. And also, I suppose you have to think about how you want those assets to transfer across as well to various people. So, For instance, if you want a particular property to pass to a particular beneficiary, there may be ways that you need to structure or spell that out in the will to make sure that happens and in the way that is of benefit to the beneficiary.
I think the understanding of what you've got, and you talked about debt before, which is an issue one that often gets overlooked, but understanding your financial position and having that quite accessible to somebody is a big favour you can make to your executor, because I think in the old days it was very much you could spend 6 months trying to hunt down all the assets and liabilities and then find all the beneficiaries and that sort of thing, whereas nowadays technology and working with somebody like a financial advisor can help you to sort of bring that together, which is a big time saving and a gift to your executor.
Yeah, so I think as well, the common feedback I get from especially clients who are aging and thinking about how they're going to leave their legacy to the beneficiaries is wanting to make it as simple as possible for them. If something happens, the last thing they want is a headache for their loved ones. So yeah, putting together a snapshot, even just a summary page of what you have and what you owe, contact details of your advisor or accountant or estate planning lawyer to help facilitate, make sure everyone's all on the same page and can provide any gaps in that knowledge is a really good starting point. And also one thing with now technology, as you mentioned, nowadays it is your sort of online presence. So making a note of what online accounts you have, things that might need to be dealt with when outside of the pure financial aspects.
So when putting together the plan, you sort of highlighted some of the key roles and people. I guess two of the really important ones when you talk about wills, your executor and your beneficiaries. And it's interesting, I think we're probably seeing more often now people wanting to talk about what they're leaving and what they've got with their beneficiaries. What sort of conversations do you think, or what are some of the things that are important to talk about with those two parties?
The beneficiaries. I think for one, an executor, when you're appointing someone as the executor, it's important to let them know as well, because that also can be something that they may not want to fulfill. They might feel overwhelmed or just not feel like they're up to the task of doing that. So having that conversation means that you're able to potentially appoint an alternative, or think about who they can partner up with potentially to help them to administer that. An executor can sort of resign from their position if they feel like they're not the best person to look after it, and then if there's no alternative, it becomes a little bit more messy for the estate to be managed. So so having that conversation is really important, as well as to the beneficiaries, because surprisingly sometimes the beneficiaries don't want the money, or they may want a particular asset. You may not be able to fulfill that need. Obviously there's other considerations around that, but it is, I think, important to have that conversation, because there are other impacts for receiving an inheritance that go beyond their personal finance. It could be impacts on Centrelink, impacts on their broader family and goals, which may not align with your wishes. So if you want to open that dialogue and be able to have some productive conversations, and it's really important to do that obviously before you get things in place.
Are there any key times, milestones that are the right time to review an estate plan?
The typical life stages ones, I would say, is as a default starting point, marriage, divorce, kids, taking on debt, potentially going through retirement, is a good. But anytime that there's a significant change in your circumstances, if there's a change in, if someone passes away who was a beneficiary or an executor, that would warrant review, or if there's relationship changes as well, people lose contact or drift apart. that would also warrant a review. It's good to do it on a, it's not a set and forget document, and to make sure that it still reflects your wishes and you don't have an ex-partner still managing as an executor on your estate, which we've seen as well.
Yeah. I mean, it's not something that people necessarily enjoy doing in terms of updating these things, and a lot of people do sort of kick that can down the road, but there are a couple of examples there where if you don't update it, then it becomes invalid, which means none of your wishes are even taken into consideration. So
that's right.
Very important.
And also when you're thinking about changes in superannuation, if you change accounts, you have to nominate a new beneficiary, which can get forgotten. The different types of nominations to make it binding on the trustee, and certain tax considerations which will flow into that as well. So having those reviews and discussions, especially with your advisor or lawyer, will make sure that your everything is dealt with in line with your wishes.
Fantastic. So I know you've got a couple of examples of where there have been issues that have arisen for beneficiaries. This is an area we talk to lots of clients about and help lots of clients about. So I'm sure you've got a few timely and important ones. So what are some of the issues you've seen in some examples?
The one that I've seen come up quite a bit is that they they're in a good position themselves financially. They want to be able to pass that on to their kids, like bypass the inheritance essentially, instead of receiving it directly. But the biggest impact of that is effect on Centrelink. So if they're receiving an age pension or any other Centrelink benefit, if you receive an inheritance, even if you decline it and pass it on, it's considered a gift. So it will be considered a deprived asset for 5 years on your Centrelink record, where your assessment will be impacted by that increase of that deprived asset. So it's very key that if you did have the intention to pass that on, that the person who's making the will actually does that directly in the will, because then that will have no impact on the intermediate generation for Centrelink purposes and aged care or home care purposes. So that's one that it's more probably towards the later life that people have sort of settled and don't have big financial needs, and they want to help the younger generation with this windfall. So again, having that discussion early and being able to voice what they want to happen will help make sure that they minimise the impact to them from that perspective.
Fantastic. So this is very complicated. There's a lot to this area. We've gone through this reasonably quickly. So if you do want to know more and discuss your own personal circumstances, I'd suggest get in touch with your advisor or Mel, who's definitely a specialist in this area. We've also got a lot of information on our website. We've really beefed up the section around estate planning, have a specific section in that area. There's a recent white paper which has been posted to there, which is, I think, some fantastic work that Melody and Kate, our marketing manager, have done to put that together. So I would commend that to you to have a look if you want some more information about things to consider and some good case studies there. So in wrapping up, is there anything else you'd like to add, Mel?
One final thing I forgot to mention about the types of information to leave with your estate planning documents for your beneficiaries is the cost-based information for any investments. And a lot of people kind of look over this, and then it's on the next generation to potentially hunt down years or decades of records, which most times are missing. So the more that you can collate during your lifetime or as you're accumulating your especially your personal assets, but really anything that you own from a financial investment perspective, the better off your beneficiaries will be, and also you if you decide to sell during your lifetime. Just makes the job a little bit more seamless.
Great call out. Very, very helpful, and your executor and beneficiaries will thank you a lot for that information.
That's right.
Fantastic. All right, well, thanks again, Mel, for sharing your expertise. Hopefully at home you found that to be valuable. And so if you have any more questions, please get in touch. In the meantime, have a great day. Welcome to the Evalesco Healthy, Wealthy and Happy podcast. My name's Jeff and I'm pleased to be your host today. And I'm very pleased to be joined once again by Senior Financial Advisor Melody. Welcome back, Mel.
Thanks, Jeff.
Today we're going to be talking about a very important topic of estate planning. I'm going to dive deeply into what's involved in estate planning and some case studies around some issues that we've seen clients experience. But before we do that, as we always start with, Mel, tell us what you've been doing to be healthy and happy lately.
So I've recently gotten back into reformer Pilates, which I really enjoy. So that's been,
Thanks for tuning in to the Evalesco Healthy, Wealthy and Happy podcast. If you'd like to learn more about anything you've heard in this episode, please give us a call on 02 9232 6800 or email admin@evalesco.com.au. Make sure to subscribe to our channel for more Evalesco podcast episodes and stay up to date by following us on Instagram and Facebook.